Hi, my name is Rich Falcone. I have been advising and defending employers in the employment arena now for over 30 years. I wanted to talk with you today about how your decisions as an employer can impact employment litigation down the road. The chances of you winning a lawsuit are going to depend upon what you do now long before that lawsuit is filed. And what I mean by that is this. You should have in place a number of foundational elements that will help defend you against a lawsuit that may be filed a year from now, 3 years from now, or 5 years from now. So building that infrastructure is very important. There are several key components to that infrastructure. One is to have someone in charge of human resources. That could be someone on the outside. I understand you're a startup and having a full-time human resource manager may not be practical, but have a experienced, trained professional on the outside, ideally on the inside, to assist you with such things as getting in place employment agreements, employment policies, making sure those employment agreements contain a number of important elements, like, for example, arbitration agreements, that will help protect you as an employer when you're sued several years down the road. Number two, all managers and employees should be trained. Managers need to be trained in relation to doing proper employment evaluations. Managers need to be honest in those employment evaluations and not sugarcoat it. If there's a problem, you need to train your managers to step up, identify that problem, and make sure the problem is conveyed to the employee. Likewise, if an employee is having performance problems, that manager needs to step up and be able to address those problems, and the manager needs to be trained on how to do that. All employees, managers and rank and file employees, need to know that you've got a complaint procedure in place that they can avail themselves of, so that hopefully you can address and resolve employee complaints internally. All employees should be aware that you're going to be subject to what we refer to as the fishbowl effect. If you're sued, communications between employees, particularly communications in writing, may be subject to discovery down the road. The other side can get that written information. So when your managers are evaluating employees, when they're communicating with human resources, they need to keep in mind that the written communications may be subject to somebody else, including the former employee's attorney, reviewing those communications down the road. So make sure that employees are trained to be circumspect in what they say in those communications and be very professional in those communications. You need to tell your attorneys everything when it comes to lawsuits. So in essence, understand that you will be sued as an employer. Understand that you can prepare ahead of time by putting in the infrastructure I described, and have that plan in place so that when you are sued, you are putting yourself in the best position possible to defend yourself. I hope you found this information helpful, and I wish you the best of success.